So let's talk about a situation where there's not a plan in place, and a judge ends up deciding who raises the children because there was no plan. What factors is a judge actually considering, and why might that not align with what the parents would have wanted?
I think the great example is in situations where the parents actually want a dear family friend to raise their children, right? And a grandparent or an aunt or an uncle believes they should be the ones that raise the children, right? And in that situation, it would be hard pressed for the sort of outsider, the friend, to be the legal guardian. And so in those situations, I mean, a court can, how does a court know that it was the friend? Because nothing was in writing. So the court by default would name a grandparent or a sibling, right? The aunt or uncle of the child, just because who else? They have to name someone or first cousin or second cousin, right? So the family member would be sort of the first hierarchy before they would even consider an outsider. I think I answered the question. So
Hmm.
the judge will consider, the family member, they're going to consider, the best situation for the child, right?
Hmm.
The living, are you uprooting the child and moving them
Yeah.
to, Florida because they've been in California, but the next of kin is actually
Hmm.
in Florida. Well, maybe the parent wanted their best friends to raise the child because they wanted them to stay in Orange County, California, right?
Well, you mentioned before in the probate episodes we've done that probate records are public. So in reality, that could expose an 18-year-old who is about to receive this inheritance check. How real is that risk, and what does proper planning do to prevent it?
Yeah. Well, I think the risk is real, right? Because the probate process is a public process, right? So if it's a public process and an 18-year-old getting ready to receive $1 million, 2 million, whatever it is, doesn't matter, then maybe there's some bad people out there, right? Creditors that, oh, no, let's start sending the credit card application. Let's start advertising these fancy cars. Let's start sending a lot of propaganda to this address that this child is going to turn 18. And so I think it's a real risk because an 18-year-old, sometimes there's some really good savvy 18-year-old, but from a whole, they've been traumatized, they've lost their parents, and then now all of a sudden they're getting this big chunk of money and they're 18. Maybe they've had good guidance, maybe they've had poor guidance, you just don't know. And so having it go through the public process it and it's where, there's some naughty people out there, as I always say, that could use that information for their benefit and not the children's benefit.
Okay. So let's get into maybe some really local specific considerations. Currently, you're in Orange County,
Yeah.
covering the Newport Beach area and lots of other areas like that. Are there any specific local considerations, schools, custody jurisdictions, court processes that affect how a guardianship plan should be structured?
Not too much. I think it goes back to the parents deciding where do they want their children to be raised if they were not able to do it, right? Do they want them to stay local? Is it okay for them to go out of state? Yes, considering the school districts, are they to move into the parent's house? What are the guardians to do if the unthinkable happen? So it's just making sure that the short-term guardians and the long-term guardians that they are updated and in place and that your wishes are going to be carried out. Same thing with the estate, right? Making sure that the estate is not going to go through probate and that there has been a trust that has been set up for the minor children so that it can be done in, increments at 25, 30, 35, or whatever it is, or asset protection as well, depending on the dollar amount that we're talking about. But it's just putting in those protections to make sure that, whatever money you're leaving them is not lost by the time they turn 19 or 20.
Are there situations specific to blended families, where planning becomes even more critical?
Absolutely. So let's just use for the short-term guardian, right? So if you're a blended family, it's a stepmother or a stepfather, that step parent actually needs to be named as a short-term guardian, right?
Mhm,
Especially if the children are living with mom and stepdad, then if something happened to mom, someone needs to take custody of that minor child, and a step parent does not have any rights. So, as long as everyone's amicable, I always like to name the step parent as a short term guardian. And then, of course, long-term guardian, that's up to the parents, how they want that to operate. But in California, the surviving parent always has the legal authority to be the guardian. They are the guardian, even if there has been an ugly divorce or it doesn't matter the situation. You can state that maybe there was abuse or drugs or, alcoholism or
mhm,
something from a parent. And so the custodial parent can say, I do not want their biological parent to serve as the legal guardian because they have the, drug problem, alcohol problem, gambling whatever it is. However, that parent can go in and become the legal guardian. They would have to prove that they are not adequate to raise the child, right? So there would have to be circumstances above and beyond that parental rights would be taken away from the other biological parent.
mhm.
So, but as far as blended families are concerned, I think it's important to name that step parent as that short-term guardian in case there's a car accident, in case someone needs to pick up the child from school or whatever the circumstances. We can name 1,000 different circumstances where the step parent really needs to be able to step in and take physical custody of the minor child.
How long does it typically take to complete a legal guardianship plan and get it in place? And is it something that parents can realistically get done with a busy family schedule?
Yes, we try and make it as easy as possible. So we have a portal where you can go into our portal and name short-term guardians, 1, 2, and 3. Long-term guardians, are you naming a married couple? What happens if one passes? Does it go to the survivor or does it go down to number 2 or number 3? So you can actually go into that portal and put all your people in, and then we can produce these the short-term guardian, the long-term guardian, custodial, and the estate within a couple weeks. So you can come in, we will notarize it, we'll witness it, and we also include a medical power of attorney for our minor children as well. Because if a parent is incapacitated, then and there's a non-emergency, someone could break their arm, break their leg, right? Non-emergencies need parental consent. And so, with the medical power of attorney, the parent will give the short term guardian the medical consent to make medical decisions for their minor child. And again, if it's an emergency, of course, the emergency gets performed. You do not need parental consent. But for those non emergencies, you actually need parental consent. And that's where we actually create sort of a power of attorney for making medical decisions for those short term guardians.